frankly, I'm just trying to wrap my mind around that concept and understand it. So I'll let you address that.
Ryan, Daniel Grossman, the NJDA case established a limit and said that the court would not compel a particular method of funding. The existence of the right and method of the funding are two separate concepts. If there's a determination of right, obviously, the judiciary enters an order, it makes a determination, and the rest of the government either honors it or it doesn't honor it. The most famous example is when Andrew Jackson said John Marshall's made his decision, now let him go enforce it. But simply because there may be a reluctance at some point in time to order a form of enforcement doesn't mean that the court shouldn't acknowledge the existence of the right. And the Supreme Court, certainly in the education area, has compelled methods of appropriation and methods of funding. So therefore, once the court makes its determination, the rest of the government will do or not do what it does. In that particular case, there was a determination by the appellate division that the method of funding wasn't appropriate for it to make a determination at that time. And that particularly is important because the court went so far as to acknowledge the right. Now, in any case that involves the court making a determination as to the validity of a statutory scheme, there's always going to be the question of what the rest of the government does, whether it honors it or it doesn't honor it. In this case, there's been a history of the government funding COLAs from the beginning of the Pension Adjustment Acts in 1953. This is aberration. Therefore, recognizing the existence of the right within the context of the history certainly is important to plaintiffs for their determination as to how they go about doing whatever they have to do. So I don't think that acknowledgement that that the court can't compel a method of funding at that point in time has anything to do with an acknowledgement of the existence of the right. In private law, you see it all the time. You enter an opinion, you enter an order, and it's either followed or not. There may be enforcement decisions, there may not be. At this particular point in time, we're asking the court to acknowledge the existence of the COLA, and for my 26 plaintiffs, at the point in time in which we filed a lawsuit and we proceeded, wasn't that much money. With the interveners, there may be another question. My 26 plaintiffs, Your Honor, might well determine that we did everything we were supposed to do under the various contracts and the liability acts, and you might make a determination that it's no skin off the state's nose, so to speak, to fund it. But that really is distinct from a determination of the existence of right.
Yeah, I mean, I guess the question is, if the legislature intended to create a contractual right that causes future legislators to have to appropriate to pay for that right, doesn't it violate the debt limitations in the appropriations clause?
No.
That's really the issue I'm focused on.
No. Because if you acknowledge the existence of the right, the legislatures will or will not honor it. But the existence of the right will have other consequences. For example, those COLAs may be unapproved, but may approve for the plaintiffs. They will accrue as part of their pension liability in such time as an appropriation comes to it, is decided. There's a basis to determine what's due. Or Your Honor may determine that the right exists and that it's necessary to determine that the funding proceed in whatever manner the court determines. It may not be an appropriation, it may be some other form, but once you determine the existence of the right, it will be up to the legislature and the governor, or the executive branch, to determine how it's funded.
Okay. I guess that's my question. Can there really be a contractual right if it is subject to future legislators changing? I'll let you address that. I understand.
Your Honor, excuse me, this
Just
issue.
identify your name for the record.
I'm
Just
sorry.
identify your name.
Oh,
for the record.
Kenneth Nowak, for the interveners. This issue has already been resolved, and the Attorney General has already agreed that a contractual or non-forfeitable right does not violate the Appropriations Clause. In 1997, the legislature created the non-forfeitable right to a benefit program. In 2006, the Attorney General offered an opinion which was provided to the Joint Legislative Commission on Pension Reform. And in that opinion, putting aside the COLA, the Attorney General said that we had a right to a pension. Now, the issue today is whether that includes COLA, but the Attorney General said that there is a statutory contractual right to at least a basic pension. If we have a statutory contractual right to a pension, then clearly the Attorney General and the legislature, because they didn't change the law after that opinion, have already bound themselves to that benefit. Again, how they appropriate monies for it is a separate issue, but the more important, the fundamental and underlying point is that we already have that issue decided. It is not as if a pension benefit violates the Appropriations Clause. That's already been decided. The Attorney General admitted it.
And I read the opinion, but why doesn't it? Because that opinion didn't really address that specific issue. Why doesn't it violate the limitation of the Appropriations Clause?
Well, actually, the Attorney General, we believe, does address the Appropriations Clause. And certainly, if they felt that it violated the Appropriations Clause, they would have said that in their opinion.
I'm not worried about what they felt back 4 or 5 years ago. What's your opinion as to why it doesn't violate the debt limitation of the Appropriations Clause? The creation of that right.
The very reason that the Appellate Division stated is that the legislature decided on its own to separate the right to receive the benefit from the obligation to fund that right. We did not decide that. That was a legislative decision to provide a right. They decided they weren't going to fund it for a number of years. They weren't funding the pension, Your Honor. So the issue that you're posing to us is a result of the legislative decision, and the Appellate Division acknowledged and recognized that and reinforced that by separating the right to the pension benefit from the funding. So we have 3 things. We have the legislator creating a non-forfeitable right to receive pension benefits, an Attorney General opinion, which they have not abandoned, which says that there is a statutory contractual right to receive the benefits. There's been no legislative action after that to change that. And we have the Appellate Division clearly recognizing both and saying, you have a right to receive it. We understand your issue, but that is how the legislature decided to do it.
I'll let the state respond.
Your Honor, if I might respond to two things. First, the critical question, the dispositive question in this case, is whether the legislature unequivocally intended to create a contractual right to the specific item at issue, here COLAs.
See, and I'm sorry to interrupt, but I'm looking at whether they even have the ability to do that in the first place.
Yes, and if you don't
Right, no, sure.
And here I'd like to address something that interveners just raised and raised in the reply brief as well. The interveners attempt to read the specificity requirement out of the unequivocal intent standard. That is, they argue that there need not be a specific intent, an unequivocal intent with regard to COLA specifically. That position fails because it cannot be reconciled with National Railroad. The Supreme Court in National Railroad said that not only must the court look for an unequivocal expression of legislative intent when determining if a contract exists, but that the court must also look for this unequivocal intent when, quote, defining the contours of the contractual relationship. To do otherwise, the court would impermissibly intrude on the legislative prerogative. And now to answer your other question. Any interpretation of the non-forfeitable rights statute that says that it guarantees the receipt of payments for perpetual COLAs runs afoul of the debt limitation clause. They cannot receive COLAs unless the legislature first appropriates funds for them. And decades of Supreme Court precedent have made clear that the debt limitation clause prohibits one legislature from binding future legislatures with regard to appropriations. And this, I think, goes to your question of whether they could enter into the contract in the first place. I think it's indisputable that at the time that the non-forfeitable rights statute was enacted in 1997, there was not, the COLAs were not fully pre-funded. In fact, in L 1994, Chapter 62, the legislature was hoping that it'd be 24% pre-funded by 1994 and 6% more thereafter. The legislature that enacted the non-forfeitable rights statute could not bind future legislatures to make up for this funding gap, and therefore could not have guaranteed payment of perpetual COLAs. Any legislative commitment that exists in the non-forfeitable rights statute concerning COLAs must necessarily be contingent upon appropriations from subsequent legislatures.
Wouldn't that same analysis apply to, the base pension as well?
I think that, yes, in the short answer, yes. I think that any time there is a statute that purports to spend funds over multiple fiscal years, then it is necessarily contingent upon appropriations. As the Supreme Court has repeatedly emphasized in the debt limitation cases where this comes up, there are, of course, other factors, although not legally enforceable. There are other factors that will come into play, such as the anticipated reaction of the financial markets or constituents that might inform the legislature's decision whether or not to appropriate funds. And if I might direct the court's attention to, I think, subsection 9.6, the one after the non-forfeitable rights statute, says that, supports this, recognizes that even non-forfeitable rights are subject to appropriation. It says that notwithstanding anything else, if the retirement funds are terminated or if funding is discontinued, benefits are, quote, non-forfeitable to the extent then funded. And subsection 70 of the first statute pretty much says the same thing, that the state retirement system is not liable for the payment of benefits for which reserve funds have not been created. So the statutory scheme itself recognizes that even non-forfeitable rights are not guaranteed payment.
Well, and then this goes back to the NJDA case, Judge Burrow's decision, which I've read this case probably 10 times now, I think, where they make a distinction. This is what plaintiffs raised and interveners raised, that they make a distinction between future appropriations under 9.5C and then Section B, the principle that the right of members to receive the benefits accruing for their past service was non-forfeitable because those benefits represent compensation. And right before that sentence, he discusses the debt limitation and appropriations clauses as prohibiting one legislature from incurring debts of future legislatures. I'm still having trouble squaring those two concepts, to be honest with you.
I think that...
I'll let you go if you want to address it.
I think that the... I'm sorry, I lost my question again.
That's okay. I'll let him address it and we can respond.
If I can address one of the points Your Honor raised is the status of COLAs within the
I'm sorry, I had trouble hearing you.
I'm sorry, so do I. I'll speak up.
It's all right.
One of the points that Your Honor raised had to do with the context of the COLAs. The non-profitability statute talks about benefits programs. And the legislature certainly know how to exclude a benefit because they excluded medical payments. Juxtapose that with the recognition in their matrimonial cases where the Supreme Court and the appellate division, Ward versus Moore and Hagen versus Hagen, both acknowledged that cost of living adjustment, pension adjustments were part of the pensions. They were just raises. Now, the defendants want to poo-poo that as dicta and the fact that they arose in matrimonial cases. But what was at issue in both cases were public pensions. And the disposition was in terms of property rights and present valuation. Well, other than a case where there's been a governmental entity fighting about whether or not a pension adjustment is part of a pension, it stands to reason that matrimonial cases where there are valuations of property rights or vehicles in which those issues would be raised, many of the valuation questions throughout all of general equity are raised in matrimonial cases. So I don't think that that's unusual at all. And candidly, it's hardly dicta because the issue there was whether or not the future COLAs were property rights. And both cases seem to acknowledge that there is a basis to actuarialize and whack it up. And as far as the NJDA case and recognition of debt limitations, the debt limitation clause and the existence of the right, all the court held in that regard was we can make the distinction about the existence of the right. And in this case, in that case, we can't tell you how to fund. You do not have a right to a specific methodology of funding. Now, in an appropriate case, Your Honor might determine that, well, you know, as the Supreme Court said in equitable estoppel context, the race for the retired pensioners is run. Somebody can quit a job if they're still working. A retiree can't. He's done or she's done. They are looking at rights that were fixed at their time of retirement.
Okay, did you want to speak something?
Yeah, Your Honor, if I could just add to what is going on here.
And just because of the record, it's just that each time you stand up, state your name.
Ken Nowak with the interveners. What we have here is a legal system that obviously is contained in the Constitution. We have in the Constitution the Appropriations Clause, the Debt Limitation Clause, and the Contract Clause. It seems to me that what the Attorney General of the state is actually arguing at some level is that the Contract Clause is subservient to the Appropriation Clause and Debt Limitation Clause. That if you find that the right to a basic pension is contractual, then still you don't have a right to it under the Appropriations Clause.
Or you could be even finer, you could be arguing that, well, the contract exists, but it's contingent upon future funding.
That's not a contract. The other factor here in defining what the rights are of the participants and retirees can also be looked at from another view. And by the way, this is a view expressed by the Attorney General in an opinion referred to, by the way, by Justice Lavecchia in the recent judicial case, judicial pension. In 1974, the legislature created a mandatory pension system for the legislators, the same as for all the other state employees. In 1974, the Constitution provided, however, that legislative compensation was to be paid in a fixed amount on an annual basis. And so the question to the Attorney General was whether a pension, which obviously is paid later, and obviously in amounts that might differ by the time they retire, whether that comported with the constitutional provision. The Attorney General, in their 1974 formal opinion number 12, stated that a public pension is a mode or form of deferred compensation where an employee receives pension service credit in a retirement system as compensation during his government service, and where the payment of benefits are postponed until after employment with the government has terminated. And it cites a long line of cases. Now, Your Honor, if somebody tells me or you that your pay includes this right, and you will deem it a part of your pay, but you'll get it at a later date, for them to then say, well, you can't get it then because we're not going to appropriate the money, then they did not pay you what you earned. The pension is earned as you work. The pension is deferred in the payment. So for the state to say that we're not going to appropriate it when you retire or take your pension is to say, we did not pay you that money. That money was paid and earned as they were working. It is taking their salary, it is taking their compensation. Your Honor, that is a contractual right, as even the Attorney General had recognized. You cannot say you have a right to pay, and then later say, well, we're simply not going to pay you for money you earned 10 years ago, 20 years ago, 30 years ago. They earned it then. The legislature simply said, well, we'll pay you some of it later.
Yeah, and Judge Pearl recognized that. He calls it compensation.
Right. As the Supreme Court has many times. There's another factor here. The United States Supreme Court, in the U.S. Trust case, which is the seminal decision on contract clause, recognized the appropriations issue in several footnotes. They made a distinction between, they recognized that the appropriation clause dealt with the reserved right theory. That is, that the state always has, not always has, but that there's the doctrine of the appropriations clause that there's a reserved right for the legislature to terminate whatever agreement it entered into. But they distinguished between the proper exercise of that reserved right for police powers, such as eminent domain and other such issues. They then distinguished whether that reserved right applied to other financial obligations, and in that case, the bond. So the U.S. Supreme Court recognized that the appropriations clause itself has certain limits. Otherwise, Your Honor, there is no such thing as a pension. There is no such thing as a contract. That is an unacceptable and way too broad determination. The appropriation clause would effectively say, Your Honor, and this gets back to the start of my discussion about the contract clause still exists in our Constitution. What they are saying is that the appropriation clause bars the state from entering into a binding contract. Yet, the Constitution recognizes that the state can enter into a contract and protects them in the contract clause. Their interpretation of the appropriation clause wipes out, eviscerates any notion of a contract.
Well, I think there's lots of different types of contracts. Some make payments over the course of many years, some can be for a finite period. So I'm not sure if it eviscerates all contracts, but I understand your point. What's your response?
Your Honor, several points. First of all, the United States Trust, page 17, shows it that the parties had both agreed that there was a contract in that case. So the first prong of the impairment analysis was not an issue. Secondly, the debt limitation clause was not at play in U.S. Trust because in that case it wasn't a matter of the legislature appropriating money. It was a matter of the Port Authority of New York and New Jersey had generated funds from its bridge and tunnel operation, and whether those funds could be used to subsidize mass transit. It did not involve at all the debt limitation clause and the restrictions that that imposes, given that one legislature cannot bind future legislatures. Second, a long line, an unprecedented, unbroken line of Supreme Court cases, Canton v. Byrne, Lonergan, Enorado, Holster, all stand for the proposition that you can have a contract, but in order for the contract not to run afoul of the debt limitation clause, there can be no guarantee of payment under that contract. So there can be...
Yeah, and that's it. Judge Perot even says that in the decision, calls the debt limitation appropriation clause sweeping and exclusive. But under that analysis, I mean, there's no right to any type of future pension benefits, right?
Right, the non-forfeitable right would extend only to the extent that they have been pre-funded, and they have not been fully pre-funded. And Your Honor, just one other thing. I object to interveners interjecting sort of deferred compensation issues and all into this case. Those issues have not been briefed, and interveners, when seeking intervention, had noted that they would take the case as they found it.
Well, let me ask this question. Go ahead.
I'm sorry, Your Honor. I just, yeah.
Suspended payments?
Yes.
So, I mean, doesn't that go down to the heart of the issue of the appropriations and debt limitations clause?
No, because we're talking about future legislatures. There's a formula. Every legislature knows what that formula is going to, every legislature knows what it's going to be, because there's a formula for calculating it, which I think is based on CPI. Well, that's the part I would have gone to medical school if I would have done that. But no, because what we're talking about is a number that can be determined by the basis of what exists at the time the appropriation is going to have to be made. There's no specific number that the legislature is binding itself to. We're not saying you have to pay this guy $1,000 a year every year. What you're saying is there's a pension that you're appropriating, and you never know how much that's going to be because people are retiring. For example, you never know who's going to retire or when they're going to retire. But that's something that has to be taken into consideration as well. So to say that putting in a COLA, making a COLA an additional, making a COLA something that runs afoul of that, just is inconsistent with the whole nature of the system. There's never any certainty. You can't control who's going to retire after how many years of service.
No, I understand, but I mean, this contractual right essentially does bond future legislators to a specific number because there's a formula, there's a CPI, and those payments would have to be made in perpetuity to vest the members and those who would retire.
Well, first of all, it's not in perpetuity because it's only we're not arguing that the law that was passed can be necessarily, that is to say, Chapter 78 of 2011. Nobody would, at least we're not, arguing that for people in the system who haven't, certainly for people in the system who haven't invested, there's no question that their rights can be affected. None of my clients are people in this situation for whom the right is vested, but they're still working. For retired, all I'm looking at is retired persons who were retired as of the date of the passage of the statute. So it's not in perpetuity. It's for the lives of those people and their spouses. So to say that this is some kind of perpetual ongoing right that's going to bind people forever just isn't accurate. It's just for the lives and I'm not going to talk about the legislation. So clearly it's not in perpetuity. So that's number one. Number two, the pension number itself, whether it's the base pension appropriation or the pension with the COLA, can never be fixed at the time of the legislature comes into session. And I don't want to repeat myself, but we don't know how big the pool is. People die. It's like Bleak House. People died when people were born into the system. Well, in this case, the retirees entered it. That's what investing. So you never know. The question is whether the COLA is part of that pension. And and it's fairly clear to us that between the judicial determinations that it's just an adjustment of that number, more be more, and A right versus A, and the acknowledgments that we contend are contained in the Attorney General's opinion, the OLS opinion of 2006, you're not binding anybody to anything. The pension function is whatever it's going to be. It's the obligation to fund, not an obligation to fix a number to infinity. I'll let Mr. Miller go.
I actually want to partly respond to what the Attorney General said and partly pick up on what Mr. Grossman said. I want you to understand the ramifications of what the Attorney General's opinion is. Their argument is that the statute only provides for benefits that the state has provided, that the benefits are limited by what the funding in the pension. Well, if that's the case, then why doesn't the legislature actually, as they have done for many, many years, simply not fund it and then say, there's nothing in the pension plan. I'm sorry about your non-forfeitable rights. The money's not there. The purpose of the non-forfeitable right, and this ties right back into the NJEA case, is that the legislature cannot, by its own misconduct, I'll say that, because factually, actually, Your Honor, not funding the pension plan is irresponsible. They cannot undermine a non-forfeitable right by simply saying, we're not going to fund the plan, and I'm sorry, when you retire, there's nothing there, therefore your right to an unreduced pension is meaningless. And I think that that's what the NJEA case was picking up on. I think what the appellate division was saying is, okay, you can decide what you want to do about funding, but you have a non-forfeitable right here, and you have to, at some point, in some manner, live up to that. You cannot eviscerate that by your own other conduct. The other thing is, Your Honor,
just answer this question. Isn't that non-forfeitable right binding future legislators?
the non-forfeitable right creates a right as you go along. And yes, at some point, the legislature is obligated to honor the non-forfeitable right. This is an issue that the appellate division grappled with. I wish I could tell you that there is a right and wrong answer to it, but I think that when you look at what the ramifications are of accepting their position, it would be that the legislature created and granted a statutory contractual right which is void of any real meaning. The appellate division would not accept that. The appellate division was faced clearly with the argument that there's an appropriation clause issue here, and despite being faced with a clear argument about appropriation, they ended up saying, well, you have the right to the benefit. The other thing is that the legislature has, on its own, now addressed the issue of the non-forfeitable right. I think it was in 2007, I'm not exactly sure of the date, maybe later. They made it in 2010. They eliminated the non-forfeitable right going forward for new hires. So the legislature basically did two things there. One is that they now, because of financial issues, decided, okay, we're going to deal with our financial situation by saying no more non-forfeitable right. We're going to eliminate that problem. But the other side of it is they did not eliminate it for people who had it. If they really felt that the appropriations clause meant that there really was no non-forfeitable right, why did they keep it and only eliminate it for new people? They recognized they had made a commitment to these people.
Let me ask you this, and I'll let you talk in a second. In Spina, which is a Supreme Court case, it said, this page 22, it's at the end of the opinion, it's the second last paragraph. The court says, quote, "In any event, we think it is clear that even in contract jurisdictions, there would be little doubt as to the power of the legislature to deal with an insolvent fund in the way in which our legislature has dealt with the fund before us." I mean, isn't that the Supreme Court saying, even if you have a non-fulfillable binding contract, the legislature still has the opportunity to make change?
We don't read it that way. What we read basically is that the Supreme Court said that the content and nature of any rights that you have under the legislature, under the law, are created by the legislature. And that here, 40 years later, or actually 30 years later, the legislature created this right. Therefore, those comments that the Supreme Court in Stina made no longer apply, because at least for that group of people who had the non-forfeitable rights, which now no longer exist for new hires, that type of reasoning does not apply because the legislature followed what Stina allowed them to do. The other is, if you look at Stina, Your Honor, Stina makes some comments about funding of pension plans. And one thing that they said is interesting. They can't imagine the state abandoning the pension system. They can't imagine it happening. The Attorney General is now saying we can abandon it. Since 1994, they've been underfunding it, and virtually in most of those years, not even funding it. The Supreme Court, even in 1964, said we can't imagine that happening. And in 1964, Your Honor, the legislature probably never would have done that. But we have a very different legislature now.
Your Honor, despite the weight that plaintiffs and interveners would like to put on a paraphrase in NJEA where the court was paraphrasing what the Attorney General had said, Supreme Court precedent here is quite clear that one legislature cannot bind another with regard to subsequent appropriations. Case after case after case says that there is no legally enforceable right to payment. There may be other issues such as market conditions or political considerations that make the legislature, that inform the legislature's decision to fund, but you cannot compel payment from the legislature. And that's an unbroken line of Supreme Court cases. And just to address what the Supreme Court did note, and we have the quote exactly right, we think it is clear that even in contract jurisdictions, there is little doubt as to the power of the legislature to deal with insolvent funds. And with regard to what Mr. Grossman said about Hayden and Moore v. Moore, again, just putting too much weight on that. A marriage dissolution case is just not relevant. And even if it were, the Moore court made clear that any right of the spouse was derivative of the pensioner's right himself, saying that there is some uncertainty inherent in receipt of COLAs. And that's because it's within and it said, the legislature, COLAs must be granted each and every year by the legislature. The power, there is no enforceable right to payment of COLAs.
Okay, well, I mean, looking at the first hurdle, which is whether the provision back in 1997, the non-fulfillable provision, whether that violates the debt limitations and appropriations laws. That's really the first hurdle. It's a threshold issue. I conclude that it does. I conclude that that non-fulfillable right, and that's the language in the statute, is contingent upon the legislature appropriating additional monies to fund that commitment. I understand that may seem unfair. That's not the question before me. The question is whether it's lawful, whether it runs afoul of the Constitution, and I find that it does. So, I mean, the language is there, but the language, whether it's a contract or non-fulfillable right, I'm not sure what the exact terminology is for it. The But the fact is that it is contingent upon future appropriations. The debt limitations clause and the appropriations clause, as has been said in many cases, are sweeping and incredibly broad. And I think that goes back to the Spina Court's statement. I understand the Spina Court, was far before the 1997 amendments, but the court seemed to envision a time when there would be a contract, or potentially a contract. And they say, even in contractor jurisdictions, there would be little doubt as to the power of the legislature to deal with an insolvent fund in the way in which our legislature has dealt with the funds before us. And that's the court essentially saying that even if we did have a contract here, the debt limitations and appropriations clause would give us the opportunity, would give the legislature the opportunity to make changes as are necessary to do so. Frankly, I think the plaintiffs had a pretty strong argument on the next hurdle, which is the clear and unequivocal language, and I think you had a very good opinion on that. But I don't get there because I can't clear the first hurdle, which is the debt limitations and appropriations clause. So in light of that ruling, what other accounts need to be addressed? I'll leave it to you. Yes.
We have a question. In light of the fact that the posture of this case was whether the COLA is included in the non-forfeitable right, and you're saying, well, you're not going to reach that issue because the non-forfeitable right statute itself, whatever it includes, or if it includes the COLA or not, is itself unconstitutional. Does that mean?
Yeah, just be careful. I'm not saying that that statute is unconstitutional. I'm saying that the law that was passed that is being challenged, specific law here, Chapter 78, Section 25, is constitutional because under the debt appropriations, the debt limitations appropriations clause, the legislature is reserved the opportunity to make changes as it sees fit to that statute. Okay.
Okay, accept that clarification. But since the regular base pension is in the non-forfeitable right, does this mean that there in fact is no requirement that the state pay?
I'm not answering that question. That question's not before me.
Okay, we just want to understand.
I understand
what
that.
you mean by non-forfeitable
I
right.
kind of thought you might ask that question, but I'm not going to answer it. That question is not before me. I have a specific issue, that's Section 25, and whether that is constitutional. I'm finding that it is because of the two clauses that I mentioned. The Constitution reserved with the legislature the power to make changes even to the 1997 law, and I find that those changes are appropriate.
Okay. I think I understand what you're saying. Quite frankly, I'm not sure I understand logically how it would not apply to the pension when they next eliminate the pension. But my other question is, if the question that you're deciding, or the issue that you're deciding, is that it violates the debt limitation clause and the appropriation clause because it will require future payments, then I would submit to you that the retirees have already had the COLA payments for the future funded under our actuarial system. Just so that you know, because this is you may know, and I don't mean to insult you by going into the explanation, but an actuarial pension system, what the actuary does is say, we're going to assume you're going to be in the system, let's say 25 years. And we're going to assume that there are certain obligations that have to be paid for you upon your retirement. The actuary clearly included the COLA in that because if you read the actuarial reports, it's in it. If you read the statutes, it requires payment for the adjustments. So what the actuary then does is say, we assume that the future COLAs for the remainder of your life will be such and such. They make these estimates for everything. They estimate how long you're going to live so they know how much money has to be put in there. What happens is they then say, okay, in order to pay that benefit when you retire, we'll assume you're going to retire at 62, we'll assume you're going to live for 25 years. This is how much we have to put in every year to fund that benefit. Someone who has retired has already been funded for everything, including their COLA. My question then would be, I understand your decision regarding those still in the system, whose COLAs may not have been fully funded. But here we have retirees who, under the actuarial system, in theory, have been fully funded.
And I think the answer to that is, in theory perhaps, but in actuality, I think it is indisputable that they have not. And there are, I think that there are three reasons why. The first would be, as evidenced in the intervener's own complaint, in the actuarial reports and in the Pew Center reports, there has been an unfunded liability in the system. And all three of those also acknowledge that there has, the funding level is less than 100%. Second,
let me just interrupt you a second, because his point is that liability, unfunded liability for people that are vested and haven't retired yet, or is there an unfunded liability just, is there any unfunded liabilities for those who have already retired, right?
Well, actually, my point is a little bit broader. The concept of an unfunded liability arises from a number of factors. For example, that you do not meet the investment returns for a year or a number of years. Another is that you don't actually fund it according to what the actuary says. So what the Attorney General is basically saying is that when the legislature fails to fund, the retirees don't have a right because they have not funded it. So this is, I hate to use this expression, but I will. You kill your parents and then throw yourself on the mercy of the court as the orphan. Your Honor, the system itself requires the funding. That's why I said that this is the way the system operates. The fact that the legislature said, we're going to amortize, and mind you, the unfunded liability is not something that's just ignored. It's recognized as the obligation and just amortized over a period of time. But the reality is that these retirees have paid all of their contributions into the system. Those contributions are applied to the basic pension and the normal cost. And then it's the state's obligation to fund it. We really think it would be unconscionable, not to mention illegal, to then say, well, I'm sorry, we didn't do what the law says, so you don't even have that right after having put in 30 years and made all of your payments. So we're talking about now whether the appropriation clause would apply to bar retirees who, under the pension laws, have already been funded.
Your Honor, I would just like to first point the court to the quote in Sabina, where it says, our legislature has in fact accepted a considerable measure of responsibility for the errors of predecessors with respect to the pension funds and deserves to be rewarded for its courage. With regard to everything else Mr. Nowak said, he's relitigating what we've already decided. The extent to which the COLAs have been pre-funded is not a question for the lawyers, it's a question for the actuaries. Whether or not that is the same for each retiree or different for each retiree, again, not a question for the lawyers to answer for, but rather for the actuaries.
If there's a pot of money sitting there for each person, as you're saying, that includes their COLAs, doesn't that limitation clause give the legislature the opportunity to move
No, Your Honor. The statute very clearly says the pension adjustment, for example, because each system has its law. NJSA 18A 66-181, that's the TPAF system. And 18.1 is the one that provides the pension adjustment benefit. It says the benefit is paid out of the pension fund. When you look at how the pension funds work, there's a pot of money, or sub-fund, in which the employee money goes into. And then there's a pot of money in which the employer money goes into. And when it comes time for the person to retire and leave the system, there's a fund which collects it all. And the benefits, the pension benefits, are paid out of that fund. It is paid by the pension fund, not by the treasurer. Does not come out of general revenues. When it comes time to pay Mr. Smith's pension for August of 2012, it is not the treasurer who writes a check out of the general operation budget. It's the pension fund that takes it out of the pension system. And that money, as you say, the pot of money's there. Now, to answer what might be your question is, can the legislature simply say, that's our money? No. They tried that, actually, in around 1992, and the IRS came in and said, you cannot do that. You cannot touch what's in the pension plan. And there's a statute, I don't remember offhand which it is, in which they agree that they're not going to touch it because it violates internal revenue law. And you might think that, well, ERISA doesn't apply. This plan still has to be a qualified plan under the IRS. And you cannot take money out of it.
But, I mean, this question you're raising is an interesting question. But I'm here to decide whether Section 25, which suspends COLAs going forward, is constitutional or not. I mean, your question doesn't really address that, does it? I mean, if a retiree has a pot of money that's already there as of this fixed date, how does the future COLA affect it?
Well, I thought that what you were deciding is that the COLA, the revocation of the COLA going forward violates the appropriation clause and the debt limitation clause. I can understand, not agree with, but I understand your position regarding those who are in the system. But my point is that the appropriation clause does not, and the debt limitation clause do not apply to those who already been funded. There's no appropriation that's going to come out of the general operating revenue, whether directly to an employee, to a retiree, or to the fund, that is required to give that retiree his COLA. That's already paid for. There's no appropriation. And I thought that that's what Your Honor was saying, is that it violates the appropriation clause for a retiree. It's already been appropriated by the time he retires.
I understand what you're saying. I'm sorry. It just took me to the top of that. Go ahead.
Your Honor, it's just not true that the retirees' pension and COLAs have been fully funded.
Well, I understand you may disagree with that. Is this a question of fact? I mean, that maybe discovery? I don't know. It's raising the issue. And, you know, if there is a pot of money that's already in that fund to pay for future COLAs of current retirees, whether that violates the debt limitations and appropriations clause, right? And that's the issue you're raising.
Yes, sir.
I think that there are two separate issues. I think the debt limitation appropriation clause goes to whether the legislature has to continue to appropriate funds for payment. And I think this is a separate issue that says that whether or not there are the extent of the level of pre-funding in the system already. And it's indisputable that the system is not fully funded, and it is not, that unfunded liability spreads across the entire system. And it's not fair to say that, or it's not accurate to say that it affects active employees one way but retirees the other. There's an unfunded liability in the system. So
So your position is that he's inaccurate, that there's a pot of money for each person that is built into the payment to pay them going forward after they retire. That's already there. Okay, it just stopped now. Let's go on.
Just a brief technical difficulty. Did you have any time to think about the issue that was raised in the
Yes, Your Honor. If Chapter 78 of the Constitution, with regard to the suspension of COLAs, then it applies equally to both active employees and retirees. The system as a whole has an unfunded liability, so each person who comes into retirement bears that unfunded liability. And
Okay, I mean, do you have any doctor to dispute that? That
Your
the system across?
Yes, Your Honor.
Well, I'll let you one at a time. Go ahead, Mr. Rivera.
If Your Honor is making a determination that the statute itself is unconstitutional on its face because...
I told you I'm not making that determination.
No, I mean the COLA statute. I thought my understanding was, and that you had made a determination that the COLA statute, the COLA portion of the law violated the debt limitation clause. Or the debt
Put my ruling on record, but go ahead.
I thought that, I understood that to be your ruling, that the statute, I'm sorry, I misstated that. It's my understanding that you found that the suspension statute was constitutional because otherwise the non-forfeitable rights statute would violate the debt limitation clause.
Correct.
And that was my understanding that Your Honor had made that determination on the face of the statute. And with my further understanding that Your Honor's ruling applied across the board because my clients are retirees, and only retirees, and it was my understanding that Your Honor had made that determination. Some question, what I'm hearing now is an argument from both sides that whether Your Honor is confining his determination to the statute as applied. That was not my understanding of the ruling because the way the posture of the case was presented only on behalf of retirees. So therefore, the ruling would apply to retirees. And if we're going, if we're going to go beyond that, it was not my understanding that that's where we were going. Whether or not, it was my understanding that Your Honor ruled that whether or not, and I'm not trying to put you in a box, I just want to, if that's the ruling, then we have a final judgment and we're done and the parties will do whatever they do. Otherwise, there's going to have to be some kind of factual determination, it seems to me, as to the count of various retirees who retired at each time. The interveners are arguing that it can be done on an seem to be arguing to me that the funding can be done on an individual basis. And the state is arguing, the defendants rather, are arguing that the funding has to be looked at in its entirety. I think that's the issue. It was my understanding from Your Honor's ruling that you were looking at the fund as a whole and not on an individual basis, and therefore it really didn't matter what the funding as to the individual, as a component of that ruling, you necessarily have to come to the conclusion that the accounts of each individual retiree were subject to the general appropriations power. So therefore, it seemed to me that the ruling was the ruling, that the statute was constitutional because otherwise COLAs would violate the debt and appropriations clause. So from my perspective, I thought that was it, and we done.
Well, yeah, and I'll let you address it. I mean, it's my understanding you're saying that there's an untouchable pot of money for retirees that already has in it their future COLA payments. That's what you're saying, right?
Yes, I'm saying several things. If I may just say it.
Okay.
First of all, The non-forfeitable rights statute says that you have the right to the benefit program in effect when you were at 5 years. That kicked in 1997. Some people then, and basically it said it would apply to you at that time or as you hit the 5 years. There were people, therefore, who were protected by the non-forfeitable right at 5 years, for example, in 2000 and in 2001 and in 2002. They are protected in that right. At that time, it is indisputable. At that time, their pension fund was 100% funded. It was as a result of two things: the pension bond in 1997 and the fact that they did a restart on the smoothing where they calculate the assets in it. They restarted it in 2001 by using a 1999 date. The reason why it's fully funded is not really Your Honor's concern, but the fact is it was fully funded. So people who retired and later, but their rights were locked in, if you will, by a 5-year lock in 2000, 2001, 1998, 1999, 2002. They had 100% funding. So what do we do with them? Because to say to them, you're now losing your COLA because we have to make an appropriation, they're going to say, but when I was in my 5th year, and that's when my right attaches, it was fully funded. They did everything, that's what the law says. The other issue, Your Honor, is that the Attorney General's position seems to be that you only have the right to whatever is in the pension fund. They're saying that your rights are basically limited by the funding. Then why isn't this the case? Let's just accept your ruling that the COLA statute is constitutional because of the appropriations and debt limitation clauses. That means that there is no way that the legislature or that this law can require the legislature to appropriate money. We understand that now they do not have to put into an appropriation bill money to support the COLA. But there's money in the fund. There is money in the fund which the Attorney General says is all that you're entitled to. Okay, if there's only $50 billion in the fund, let's use the fund to pay the COLA until there's no more money in the fund. That money is there. And we accept their argument for this purpose only. If they're not going to appropriate, and by the way, they did not appropriate in 03, 04, 05, 06, 07, or virtually, and yet they paid the COLA. Where did they pay it from? Not an appropriation. They didn't appropriate it. They paid it from the corpus of the pension system. And that's their argument. And why can't we? That does not require an appropriation bill. That money is in there. Let's just complete it. I'm not being sarcastic, Your Honor.
I understand your point. But, I mean, doesn't that go then to E1, which limits the right of the state to alter, or nothing in the act that limits the right of the state to alter, modify, or amend such retirements or funds? I mean, isn't that what that provision in E1 is for? Is to give the state the flexibility to, well, we don't have to have the payment, but we can still pay the COLAs out, or we can change how we want to administer the funds. I mean, isn't that what you're talking about here?
Well, what I just want to I'm not sure what that is talking about. Clearly, the right to modify does not, in our mind, mean the right to modify non-forfeitable right. What it means is the right to modify have a pension fund, in a sense, is funded, operated, those laws. Apparently, according to the NJEA case, and perhaps Your Honor, they can do whatever they want with funding. And let's accept the fact that they're not going to appropriate money for COLA. Let's go further. Let's accept the fact that they're not going to appropriate money for the pension fund at all. But there's still money in there that does not require an appropriation. Why can't these people who, when they were at 5 years, locked into a certain benefit, get that benefit until there's no money left. That's the Attorney General's argument. You are only entitled to the money until it's gone. And we're saying, okay, we locked in at a certain benefit, which Your Honor, I think, indicated would include or could include the COLA. And if that's the situation, and I locked into the COLA right, and there's a certain amount of money left, don't appropriate anything more, give me what's in the fund until it's gone.
I understand.
Your Honor, in enacting Chapter 78, the legislature crafted a comprehensive set of reforms that were designed to ensure the long-term sustainability, stability, and solvency of the system for everyone, for current active employees, for retirees, for those who have deferred their retirement payments, and for the taxpayer alike. It is not and should not be this court's role to upend that balance. The legislature retains the right to decide how funds are allocated. If, as you ruled, Chapter 78, Section 25 is constitutional, it is constitutional as to both active and retired employees. Discovery would get us nowhere.
Okay. I'm going to respectfully understand your point, but I disagree. I mean, what you're talking about here, I understand you're saying that there's money that's already appropriated in a specific fund that is non-fulfilling for these individuals. The fact is that the executive is given discretion in terms of how that money is paid out, and that's provided for in E1. Respectfully, I don't have to reiterate my earlier ruling, but my earlier ruling is that Section 25 is constitutional and would apply to retirees in those vestiges. Okay? Just want to say I've done an excellent job on the briefs, so I went over this for quite a long time. I've read these cases many times, and your briefs were very helpful in going through it. So, I just need a form of order. This is a summary judgment motion. That's the way I look at it, because there were documents outside the pleadings submitted to me. So it's a summary judgment to grant on your part to dismiss. I don't think there was a form of order. I just said it's C1. Mr. Gross?
Your Honor, I submitted one. I have the right to not.
Okay. I'd rather one, just one from the state.
I have one has to be recorded, and I apologize. And so I'd like to go to the appeal. And one of the questions on the forms is whether Your Honor intends to submit a written opinion. So if the expense is being employed, then I ask whether Your Honor is prepared to tell us whether you're going to.
Yeah, I mean, this is an interesting issue. I would love to write one, but I frankly don't have the time. I have hundreds of motions every cycle, and I just don't have the time. I'm up every night reading motions, and I wish I had the time to sink my teeth into it, but my opinion is on the record here today.
Thank you. So you can just check off the box.
You can.
Thank you.
Thank you.
So what do you for the next argument?